Hi, I'm Ryan,
And this is Ray.
and today we're going to be talking about international law and its effectiveness. So, Ray, do you want to start by defining what international law is?
Yeah. So according to the textbook, what international law really is that it's a body of rules that binds states and other agents in the world in world politics and is considered to have a status of law across borders globally. Now, a couple main factors in international law are obviously the actors involved, and three of the main actors involved are usually intergovernmental organizations, states, and NGOs or TANs.
So, um, how these international laws are enforced are through um, things like sanctions and diplomatic resolutions, and when there's a problem identified, um, we start to see the boomerang model come into effect. And what the boomerang model is it describes the system of how NGOs um, who identify a problem within a state, um, like and get blocked by the state, so they can't like have influence, go through TANs and other um,
Yeah.
international NGOs to influence other states and get the other states to act against the state that they initially saw.
Yeah, just so we know what we're talking about, when we say TANs, we are referring to um, transnational advocacy networks. And essentially, it's almost as if it's an international system of NGOs. And so, in the boomerang model, when an NGO spots a problem in state A, for example, when state A blocks that NGO can go through the TANs, like Ryan mentioned earlier, who would then, through an alternative state, introduce that problem in an intergovernmental organization to then put pressure as an international community on state A to make said change.
Yeah, and I think it's very important to also point out the fact that not all international laws are created equal, and um, depending on how precise they actually are, and the punishments for defecting from the agreement determines the obligation of each state to abide by what these international laws are. So some are a lot more binding and obligatory than others are, and some can be very vague, and the meaning be up to the interpretation of each state.
Yeah, and so that kind of brings us into um, two main terms. One which is precision, which is the degree to which the international legal obligations are fully specified, and the precise rules and the narrow scope for interpreting that law makes it a significantly stronger law, like Ryan mentioned earlier, and it um, it does a couple things. It one prevents states from kind of like bargaining or negotiating around that law or trying to find loopholes because of how specific it is. And the second thing, as a result of the specificness of the law, it is often enforced in a much more successful manner. The other thing was obligation. Do you want to take that one?
Yeah, so obligation is the degree to which states are legally bound by an international rule. So a high obligation rule must be performed in good faith, and if breached, require reparations to the injured party. Um, and oftentimes, this will be like the punishment for breaching the agreement will be stated prior to the agreement. So there's both sides are aware of um, what the consequences are, and this is mainly to reduce the commitment problems of each state, and because that has in the past been a problem when there haven't been third party intervention and oversight.
Yeah. So to sum it off, obligations and precision are two of the main keys, or like two main factors that help the international community, that being states, TANs, and intergovernmental organizations, to enforce the international law. Now, the thing with international law is that it doesn't affect all state. In theory, it should affect all states equally because all states are sovereign, and by definition of that, they have equal footing on the world stage. However, in reality, that's not quite the case. A nation in West Africa, like Sierra Leone, for example, would not have nearly as much say as the U.S. would have in the UN, and so the effect of international law would be different in those two cases either. And so the example we want to talk about is comparing reactions between the Rwandan genocide and what is happening with the Uyghur Chinese Muslims right now, which is also being coined genocide by several human rights activists. So Ryan is just going to kick us off with the Rwandan side of things.
Yeah. So the reason why we decided to talk about the Rwandan genocide is because to a lot of people in the international community, it opened up their eyes to what the consequences of their action or inaction could be, and it really highlighted a lot of pitfalls in the international system. And what we want to examine is kind of if there has been a change in response to the current situation in China, maybe what the differences, some differences are and some similarities are in the international response. So to start off with Rwanda, it was somewhat difficult for the UN to get reliable information from people who were actually in Rwanda prior to the genocide happening. And while there were early warning systems, none of them were flagged by the UN because they didn't seem out of line with like, or they didn't seem what could be considered as a warning sign. However, to the OAU, which is the Organization of African Unity, they saw these warning signs as what they really were,
Like red
pretenses
flags.
for genocide.
Yeah.
And they requested aid from the UN, but didn't get it because of a lack of political will from Europe and the United States to invest heavily into a region that won't see much profit for them. And so there wasn't the care to invest in people who actively saw the warning signs, and the warning signs weren't being heard by the upper management of the UN.
And so that's kind of how international law has been. So obviously, a genocide is against international law, and despite that being happening in Rwanda at the time, it was overlooked. And that kind of comes into what we were saying earlier about how there's discrepancies in international law and how the international community reacts differently to to different nations regarding the law because of the power of that nation or how profitable that nation could be if they are given aid and other financial benefits.
Yeah, and and so one final thing is that the Rwandan genocide was not called a genocide until after the conclusion of it, and by that point, sending in military troops didn't improve the situation at all, since the deed had already been done. And the reason why they didn't call it a genocide is because of the responsibility to protect, which is the obligation for all countries to intervene in a genocide and protect civilians when their government fails them. And that brings us to what's going on with the Uyghur people in China.
Yeah, and so in a sense, it's similar to what happened prior in Rwanda, where there is a extremely high death toll, but the reasons for it are different. In China, the government is systematically placing the Uyghur people into essentially concentration camps, which they're terming as vocational re education camps, which somehow seem to have a lot of deaths in them. And so the evidence is quite clear that there is a lot of um, systematic killing that is being taken place in China. However, the reaction by the international community has been very limited. A lot of nations have called China out on it and have um, said that what they're doing is wrong, but that seems to be where the buck stops, and they can't take any further action. And this is because the boomerang model in this case doesn't seem to work because China is not exactly a democracy. If, say, for example, there was an NGO in China that was appealing against this and they were being blocked by the Chinese government, they would ideally go to a TAN and then try have the TAN influence another alternate state, which then in turn to helps an intergovernmental organization place pressure on China. That cannot happen because China has blocked out all NGOs or TANs from having any real influence in this. And another reason that it's hard to place anything other than soft pressure or slapping China on the wrist and saying don't do this is because China has a very tight grip on the world economy, specifically for manufactured goods. If nations try and start placing heavy sanctions or big tariffs or anything along those lines, they would only end up harming themselves more than harming China because of the current economic might of China, to say the least. The US and other like minded countries have have an obligation to act to end the ongoing atrocities, but they can't make these important steps to end them because of the situation that China has. So, in the sense, China is the opposite of Rwanda in the sense that it is a lot more powerful, and that's why the international community can't do anything to them. Whereas in Rwanda, they were a lot weaker economically, not very strong, and which is why the international community ignored them. So those two main key differences brings us on to our next segment on what the differences and similarities were in these two cases and why these differences and similarities existed.
So, one similarity that we see between the two is a failure of the boomerang model and TANs. Um, in Rwanda, it was because other states didn't have the financial means or political will to affect the situation that was going on in Rwanda. And in the Chinese case, they're able to block the Security Council from sending investigations into China, and they have the power to defend themselves from the international organizations that are meant to be watching for human rights. Um, and in both cases, this has led to a delay in the response from the international community and how quickly they've been able to act because of the lack of political will and lack of financial means to enforce their perspective.
Yeah, and a difference, however, between the Rwandan and Chinese situation is that the Rwandan government tried desperately or wanted desperately for it to be considered a genocide so that the international community um, sits up and takes notice and um, comes in and tries and help the people against the genocide. Whereas with China, they're trying actively not to label it a genocide because they want to prevent the international community from stepping in and you know placing the right steps for um, the human rights and the UN Human Rights Council from being able to do its job really because of the way that China is labeling it and is essentially forcing its allies to label it as well. Pakistan, for example, um, has repeatedly given no comment on the situation despite being one of the closest allies of China and have simply said that whatever China is doing is completely fine despite the overwhelming evidence.
So, what does this say about the authority of international law and institutions in general. We see some lack of a capability to respond, um, to be able, through international organizations, to go into countries and investigate what is happening, to get reliable information, to like truly act on it without having accusations of altered information or untrue information to further one side's strategic advantage.
I, th-
Um,
I think overall, um, in terms of what does this say about the authority of international laws, it speaks very much to how international law tends to only be able to bind states to the extent that they want to be bound. China doesn't want the international community stepping into its affairs regarding whatever they're doing, whether it's concentration camps or whether it's genuinely like vocational re-education camps. They do not want the international community meddling with them, and they do not want um, their like the government doesn't want anyone to put any checks on it or limit its authority or power to any extent. And that kind of brings us into our final segment on whether states can truly be controlled by international law or not. And so there's two main schools of thought, a traditionalist school of thought and the globalist school of thought. So Ryan, why don't you take us through the traditionalist school of thought?
yeah, so the traditionalist school of thought is that international law only binds states to the extent that they want to be bound. So they only benefit the states, help with coordination, and things like that. And transnational networks exist only because states that might otherwise regulate, control, and limit these interactions of those networks permit them to flourish. Um, and so states will only create laws to govern themselves that will help benefit them economically or politically in terms of security as well. Um,
Yeah, and globalists on the other side argue that international law and TANs or the transnational advocacy networks are emerging as effective forms of governance on a global scale. Essentially, what they're trying to say is that political authority that used to be exercised by states is now merging and migrating into this supranational authority which regulates states entirely through international law and through TANs. It's a much more far fetched viewpoint. It's definitely not what is going on in the world currently today. It initially Ryan and I were going to debate between the traditionalist and globalist point of view. However, we decided against that simply because the globalist point of view seems highly ineffective and unlikely in the sense because for the globalists, international law and international norms um, are increasingly constraining states in their actions, both domestically and the actions and interactions between states. That's what globalists. That's what the globalist viewpoint is. However, that's definitely not what's going on in the world right now, and doesn't seem to be the trajectory in the near future either. What is definitely going on in the world right now is the traditionalist viewpoint, like Ryan mentioned earlier, where states want international law that binds the states only as long as they want to be bound. And even the TANs exist only because the states think that they're an effective way for limiting interactions and regulating control and network permits to flourish within um, the state and other states. So overall, personally, I would say that states can't truly be controlled by international law on a small scale effect or a medium scale effect. If there's an international law that is like a major, like if state A deploys nukes, that's probably when the international community will come in and try and enforce international law. But otherwise, international law is kind of limited by the willingness of states as a whole to implement it.
yeah, and I see that the globalist point of view could potentially come into fruition in the future as their ways are found to make laws that are more binding and more precise and can constrain governments. However, at the current point in time, there's just not a way to do that. And like the traditionalist point of view that like the states are only going to bind themselves as much as they want to is what's happening because China doesn't want to be bound by the international community and they don't want to have international observers seeing what's going on in these camps. So they simply block them because they have the power to do so.
Yeah. Um, that's it from us on our short little podcast regarding international law, the effect it has on different nations, and the effect it has on whether states can truly be controlled by it. Thank you.
Thank you.